Welcome to the First District Court of Appeals. We have one case set to be argued this morning. It is Brock versus Hamilton County Board of Zoning Appeals, case number C-24-0133. And I see that both of you are here, I assume, ready to proceed. Yes? And yes? Okay. Mr. Brock, you can come forward. And you'll have 15 minutes to argue this morning. You get to go both first and last, so you can divide those 15 minutes up however you like between your beginning presentation and your rebuttal. How many minutes would you like to reserve for your rebuttal?
5 minutes, please.
All right. And you may begin when you're ready.
Okay. I'm Christopher Brock. Alongside my wife, Leanne, we stand before you today, not merely as pro se appellants, but as property owners confronting a systematic dismantling of our constitutional protections, the rules of the Rural County Zoning Code, and the Hamilton County Board of Zoning Appeals. Why the county would have this court believe our case involves a simple 96 square foot accessory structure, what truly lies behind this is a disturbing pattern of government overreach that transforms a basic property right into an unconstitutional taking through arbitrary enforcement and fraudulent proceedings. The record before this court reveals a local zoning department and ZBA that has trampled our fundamental constitutional protections by conducting a warrantless search of private property, enforcing zoning codes without facts, deliberately obstructing appeal rights by withholding crucial documentation, forcing us into simultaneous criminal and civil proceedings. A legally defective notice of refusal misclassified our property and our township. Knowingly false testimony presented to the Board of Zoning Appeals was taken as fact. The county attorney's sanctionable misrepresentations about our filings hindered our ability in common pleas court. And our judicial misconduct in handling and mailing of our crucial rulings were actually very deliberate in our findings. Systematically, our rights were violated, and we are here today to have that remanded to a lower court. A little bit about our property. We have a 1.4 acre property located in Miami Township. It's uniquely challenging due to its dual access layout. We have two different access points with our frontage on South Road. Our secondary access is a private easement, private drive, clearly marked, that leads to South Point, in which the entranceway to the private easement, our door front faces east. Our home is completely invisible from public roads and only accessible via private property. The standard in which we're looking for a permit should have been we should have been capable just to receive a permit. Instead, we actually had to file for a variance. We started this process based upon an unlawful enforcement action. We were contacted by the county on April 21st, 2022, that we had a non-conforming structure on our property. From that, we immediately went to the ZBA to file for a permit, in which we did not receive at the time a notice of refusal, but ultimately a notice of refusal was created, making us file for a variance. What we found, that there was an unlawful basis for this enforcement action. Our property is completely private. It's not accessible nor visible to public roads. However, the zoning inspector did illegally enter our property to commence this zoning action.
Mr. Brock, just so I understand, am I correct that it's your position that the shed physically can't go in your backyard because of the unique topography of your property?
In certain cases, yes, I would argue that it's actually in my back property now, and that according to our notice of refusal, it lists us, the notice of refusal says we are in Green Township. The county utilized our easement, not our frontage. Our frontage is on South, and if you look at the map of our location, we properly placed this in our backyard. On the easement, our front door actually faces east. This is in the far west part of our property. So in our contention, it's always been that we place this in a place we could get a permit. From that, an illegal zoning enforcement action was commenced against us, where the county did not get consent, they did not get a warrant, nor did they have a signed written complaint, which is required by 24-1 of the zoning code to start an enforcement action. So the county completely started this enforcement action, arbitrarily pushing us into filing for a variance.
So you didn't try to get a permit before you built the shed?
We looked online. At the time, it's a 96 square foot structure, so it does not require a building permit. And nothing on the county website stated that we needed a zoning certificate. We did find the zoning code for the rural Hamilton County zoning, and it stated that you do need to get a zoning permit. So when we found that out, obviously, we wanted to comply.
But you didn't try to get the permit until after you were cited?
Correct.
Okay.
So with that, we did ask if there was a signed written complaint to Brian Snyder. He is the zoning inspector, and he said if a complaint was filed in writing, we would have that on record, and any such records will be provided in a subsequent email. However, we do take anonymous complaints, and once we have investigated a complaint and found a violation, the process begins regardless of where the complaint came from. That is not according to the rules set up by the rural zoning code. It would be by 24-1, a signed written complaint would be the critical event that would start a zoning enforcement action. So with that, we went to our ZBA hearing. There was a secretary report or a staff report created. According to the zoning resolution 17-4.4, that there should be a professional recommendation by the county. There was none. During our ZBA hearing, the trier of fact, the ZBA, heard, and this is on the minutes and in the transcripts, multiple false testimonies that said there was no sheds that have ever existed in our neighborhood. There's approximately 10, some with variances, some with permits. With that, we tried to affirm that we've seen structures in our neighborhood, but we were totally dismissed by the ZBA. Furthermore, there were also talks by the original builder of our neighborhood that he continuously spoke about restrictions. So did some other people that gave public testimony. The Commissioner Sprawl at the time said, "You're bound by what's in the deed." Well, it's all about restrictions. From our understanding, private deed covenants are not to be considered by the public. But if you look at the transcript, it was heavily influential in the decision by the ZBA.
When you say that there were other sheds in the neighborhood, did you present any evidence in that regard, or you were
Correct.
just?
We have something called CAGIS, C-A-G-I-S, and it shows multiple locations with these sheds or accessory structures. One is my direct neighbor. We, like, at the end of our private easement, they have a garage that is a secondary structure that came after the home was built and after the deed restrictions were no longer impactful or effective in our neighborhood.
But is it I mean, your shed, the issue with your shed is that it's located, they are saying in a part of the yard that it's not allowed to be in. You would be permitted to have that shed in the backyard, right?
Yes, but
Okay.
if you look at the notice of refusal, they used my easement, which is my backyard. They used my backyard and labeled it the front yard. My frontage is south. On south, my frontage would place this in my backyard.
Okay.
By changing my frontage, the county has changed the designation of the facts that this was placed in our backyard and only visible via an easement.
But the other sheds you're talking about, are they located in the people's backyards?
Some have, actually, one has a variance that was granted that's in their front yard.
Okay.
Very visibly, so it's a bizarre act.
But your main argument here is that your shed is not in your front yard. It is, you're saying your shed is in your backyard.
Correct, and we should have been able to get a permit, and we should not have ever been cited, pushing us through legal, I don't want to take up all my time on this, but we were actually cited, and that's when we were able to file our appeal documentation. For some reason, our post-hearing documentation was withheld by the ZBA. The ZBA filed a citation through zoning enforcement, putting us in municipal court. We have immediately filed an appeal. When we filed an appeal, In the Common Pleas Court, we were able to go through two simultaneous courts at one time, mainly the municipal court. That was a citation that we had dismissed in July of last year for want of prosecution. There were no bill of particulars. It was an illegal search of our property and other misnomers. Without that post-hearing documentation, it prevented us from proper due process that we should have been able to get to this court today before ever fighting a municipal case. So we had to file in two different court cases without the ability to stay the court case that was at municipal court. So this has been a very jeopardizing situation for our family having to fight in these locations. Also dealing with Common Pleas Court, I guess, appellee filed that the Brocks never filed a merit brief in the Common Pleas Court. We did, it's docketed and on the record. So the entire county argument at the Common Pleas was that the Brocks did not file a merit brief. Instead, we absolutely did. Not one point was argued against, and instead, we were placed in a situation where the judges at the lower court reviewed our case, and that was never corrected. So I feel that that may have influenced or prejudiced the judiciary to not look at our issues and instead just throw our case out.
And Mr. Brock, you're out of time.
Okay.
You can reserve the remaining 5 minutes for your rebuttal. Thank
Thank
you.
you.
And Mr. Munoz, we'll hear from you now. You may begin when you're ready.
Good morning, Your Honors, and may it please the Court. My name is Eric Munis, and I represent the appellee in this case, the Hamilton County Board of Zoning Appeals. This case is an administrative appeal originating from proceedings at the Board of Zoning Appeals. Because the record in this case supports the Court of Common Pleas decision by a preponderance of reliable, probative, and substantial evidence, the Board of Zoning Appeals, or the BZA, respectfully request that this Court affirm the lower court's judgment. Your Honors, the question of review, the standard review in this case.
What's our standard of review here?
Your Honors, the question for this Court is to look at strictly a question of law and whether the Court of Common Pleas judgment was supported by a preponderance of reliable, probative, and substantial evidence. This Court's ability to review is more limited than that of the Court of Common Pleas. The Court of Common Pleas is given some broader ability to review the evidence in the record as taken by the Board of Zoning Appeals. And the Court of Common Pleas is to affirm unless they find that the Board of Zoning Appeals order was unconstitutional, illegal, arbitrary, capricious, unreasonable, or unsupported by the evidence. This Court's question is only to review the Court of Common Pleas judgment for whether or not it was supported by the evidence.
Could you address the claim that the administrative record contains evidence of other sheds in front yards, perhaps one with a variance?
The record doesn't contain explicit evidence of those sheds or the details concerning those sheds if they exist, if there were variances granted. I'm unaware of specifics regarding those. I know that there was testimony in the record, and this is in the minutes from the Board of Zoning Appeals meeting where the public comments from persons that were notified of the variance request appeared and claimed that there were no sheds in the neighborhood. I'm unaware of details concerning the existence of sheds, and I don't think the record supports the appellant's claim that there are sheds and that variances were granted to others in the neighborhood.
Are there cages documents in the record?
Not that I'm aware of. There might be. I apologize, Your Honor. I don't have a great command of all of the documents in the record, but I'm aware of what occurred at the zoning hearing.
Well, let's say that there are.
Okay.
Let's just take a hypothetical here.
Sure.
Let's say that there are documents in the record that would reflect at least a variance granted for a front yard shed. How would it not then be arbitrary to deny this one?
That's an interesting question, Your Honor. I would want to know more details about the specifics of why the variance was requested by the other property owner, the circumstances concerning that specific property, the process that they undertook to obtain that variance. Was there public comment against it? Was there an analysis done of the location of the shed that found it appropriate or inappropriate or different from the case at hand?
And whose burden would it be to flesh out those differences or distinctions? Is it the Brocks or is it the BZAs?
Your Honor, the Brocks in this case would shoulder the burden to show that they're entitled to a variance.
Thank you.
But is your argument in this case based on your belief that there is nothing in the record that demonstrates that there are other sheds or that there is another shed with a variance? I mean, is your argument based on the fact that you believe that there are no other sheds in the neighborhood?
No, Your Honor. The argument is that the Board of Zoning Appeals held a hearing based off of a request that they received from the Brocks. They followed the procedures for that hearing. They notified other property owners in the area and posted public notice that there would be a hearing. They investigated the request. They identified that the shed in question was located in the front or side yard of the property, which is against the zoning resolution, excuse me. And hearing evidence and the request from the Brocks and the testimony opposed to the variance, they made a determination that was supported by the evidence that the variance should be granted. So it is not totally dependent on whether or not there were other sheds in the neighborhood, Your Honor. It's a totality of the evidence accepted at the Board of Zoning Appeals. And there was ample evidence opposed to the granting of a variance such that in a 5-0 decision, they decided against it. And on review, the Court of Common Pleas saw that evidence and found that the Board of Zoning Appeals decision was legal and supported by the record.
And then what about the claim that the front yard is actually the backyard, given the layout of this property and the easement on it?
Your Honor, that is a little confusing in the argument presented by Mr. Brock. My understanding of it is that the frontage he refers to is, I think, a panhandle that goes out to a public thoroughfare, and there's a private drive that comes up into the neighborhood where he and his neighbors live. The front door to his house and the driveway from the private drive, you look, and there's photos in the record that show from that private drive, you could see the front, what most people would consider the front of their home, and then the shed, right there in the side yard visible.
Well, correct me if I'm wrong, but doesn't the zoning code define front yard not by the location of a structure on it, but by, like, its character somehow?
I don't know the specific answer to that question, Your Honor. I would submit to this court that the spirit of the zoning code wouldn't hinge on orientation of panhandles or specific frontage on a public thoroughfare, but rather the spirit of the requirements in the zoning code refer to common understandings of property.
Can we agree that front yard and backyard are defined by the zoning code?
I believe they are, Your Honor. But in this case, the photos in the record show what, by all regular understanding of what the front of someone's home is. There is a shed, very visible right there in the front side yard of the Brocks property. So it's understandable that anybody looking at the zoning code would consider that to be the front and side yard. And I don't believe that the zoning code would support a determination that the shed is actually currently located in the backyard of the property.
That seems to be the key argument today, is that the shed is actually not in the front yard. How was that argument carried forward by the Brocks from the beginning of the proceedings before they got to this point, from then until then?
Could you repeat the question, Your Honor?
Sure. The key argument in front of us is that the shed is not in the front yard, okay? And that particular position or argument, how is that carried forward by the Brocks when they were in front of the BZA and when they were in front of the Court of Common Pleas?
If I understand the question, Your Honor, I believe you're asking if the Brocks presented this argument at all steps of their case. You know, the record is, I think, confused and conflated with a lot of different things that were going on. There was some time spent during Mr. Brock's presentation this morning presenting, you know, a list of grievances related to the way the zoning enforcement action was carried out, and how that there was a, you know, separate legal proceeding concerning that going on at the same time as his efforts in front of the Board of Zoning Appeals. I don't believe that the record ever supports a finding that the Board of Zoning Appeals wrongly identified the location of the shed. I believe that the explanation by Mr. Brock is an effort to I believe that
My question is a little different than
Okay.
what you're responding to, okay? Because, and it's okay if you don't know, I'm fine with that answer, to be
Okay.
honest with you, okay? Just, you know, how was that argument developed in the BZA and how was it in the Court of Common Pleas? And it's okay if you don't know, if you don't have command of the details, because I understand there's a lot to this record.
Yeah, I'm not sure I have the ability to answer your specific question. I believe at the Board of
Okay.
Zoning Appeals, the minutes of that hearing, it does not appear that there is a real effort made to identify that part of the property as actually being the backyard of the property. On appeal, I know that it was part of the presentation at the Court of Common Pleas, but to what extent, I believe it's in there somewhere, to answer your question.
But if it were in the backyard of the property, they wouldn't need a variance, right?
I believe that's correct, Your
They
Honor.
would get a permit.
Um,
Because what we're dealing with here is the denial of a variance.
That's correct, Your Honor.
Okay.
And they did not take an administrative appeal from the denial of the permit that they sought, right?
So the procedural history in this case, Your Honor, I believe upon learning that their shed, at least in the eyes of the county, was not located in an area that it was allowed to be, they sought what is called a zoning certificate, essentially a piece of paper that says you're allowed to have this here. When that was denied, then they sought the variance at the Board of Zoning Appeals.
But they did not appeal the denial of that certificate.
Well, no, other than seeking a variance from the zoning as applied to their property.
Right. But they did not make any argument in response to that denial that they were entitled to the issuance of the certificate.
Not that I'm aware of.
All right, thank you.
To address one argument brought forward by Mr. Brock concerning arguments made at the Court of Common Pleas, there was a brief filed by Mr. Brock at the Court of Common Pleas prior to the issuance of a case management schedule by the magistrate. When it came time for the appellees to file their brief, there was a comment made that after the issuance of that case management schedule, no brief had been filed by the Brocks. There was no claim that no brief had been filed, period. And beyond that, there was nothing in the record to indicate that the magistrate or the judge's review of the magistrate's decision ignored Mr. Brock's filings or didn't consider that there were things filed in the record. So to the extent that that is an argument being presented by appellants this morning, I think a reliance on that is misplaced.
So why was the variance denied?
The Board of Zoning Appeals, in considering the evidence before it, found that there was opposition to it and that there was reason to not grant the variance.
Well, opposition, I mean, that, just because people don't want a variance, that's not a ground for denying it, right? I mean, they have to look at the criteria in the zoning code.
Certainly, they considered the zoning code, they considered the specific instance, or the specific facts concerning the Brock's property. The record supports that they looked at the zoning code. It's recited in the resolution denying the variance request. And the minutes of the proceeding consider that the Brocks were able to present their request for the variance, that the Board of Zoning Appeals staff presented the zoning code as applied to this property, and that there was additional evidence taken in the form of public comments. And considering all these factors, the Board of Zoning Appeals did make a decision, and as I mentioned earlier, it was unanimous.
Can you articulate the factors? Is there a way for you to just, in very simple terms, explain why they denied the variance? Like, for what reasons?
I'm not able to articulate the specific factors that they considered this morning. I know that some of the questions presented are there alternative areas where the structure could be placed? Is there need for, is there hardship presented to the property owner by not receiving a variance? And similar such factors are considered. And they are articulated in the zoning code, and I believe the record shows that those were considered by the Board of Zoning Appeals.
And don't they typically look at the character of the surrounding neighborhood as well and how a variance would impact the surrounding properties?
They do, Your Honor.
And is that where the public comments would have come into play?
I believe the public comments are exactly related to that issue. Some of the public comments specifically referred to that the shed being located impacts the neighborhood. And, property ownership is an interesting, it's an interesting thing where individuals have very specific ideas and opinions of what affects their own property. But certainly when there's a zoning code that applies not to just one property, but to entire neighborhoods or parts of the county, that is an understandable factor that property owners might feel that they have a right for things to not go against that zoning code.
Thank you. You're out of time. We appreciate your argument. Mr. Brock, you have 5 minutes remaining.
Thank you. So to answer a question from a little bit earlier, on June 14, 2022, before our ZBA variance application, our statement said our front door faces east on South Point Drive. We disagree with the assessment that the structure was placed in our front yard. The matter of variance, our property is 75% steep slope, which is a 20% grade. It's probably much more severe than that. Our property, 1.4 acres, leads to the Hamilton County watershed with 2 dry water courses.
And Mr. Brock, when you're describing that, and I want to avoid using the term front and backyard because I understand you to kind of dispute how those appear in relation to your house. So I want you to just focus in on the area of your property that you can see out the back of your home. And I'm not going to call that your backyard. But that area of your property that when you look out the rear of your home that you can see, is that the portion that you're talking about that has that steep grade?
It's our entire property. We have an incredible grade. I think it drops around 250 feet over 1.4 acres. So it's one of the more substantial. We're actually on something called the Nope Formation, which is shell and very steeply set. FEMA considers any home in this area, whether it's on the east side or west side, one of the most high risk for landslides. So we are built on the side of a hill.
Then can you tell me specifically about the part of your property that you see when you look out the rear of your home?
It would be a private drive easement where we park and we have a basketball hoop, and no one can really see it because there's 2 retaining walls in that part of our yard that we're looking at. So it's probably about a 25-foot drop when we're looking out that side of the home. When we look at the other side of the home looking south, it is probably another 130 to that we can see, and then it goes into that panhandle. So it's a very steep slope, one that would honestly get a variance anywhere else in the state and probably the United States. The fact that that wasn't looked at is a true physical characteristic of our property that we did not create. And moving this anywhere on our property is impossible. It'd make it non-usable, meaning as a homeowner, we are denied substantial rights of ownership.
But did the BZA specifically find that you could put it behind your home?
They never really gave us access. Honestly, this was from ex parte conversations from one Brian Snyder, and every process in here, it was an illegal search. We were not given our information. We had the FOIA requested to get it. We got cited. We went through criminal court. We had to fight just to be docketed in this case. And so everything has been thrown out on a technicality instead of the facts. The fact is, we should have been given a note of refusal up front to fight. We were not. We had to FOIA it. Every step has been difficult with the ZBA. We should have been given a permit. Our notice of refusal says that we are in Green Township district maps. We are not. It was wrong from the start. With that
Mr.
misclassification.
Bragg, a quick question on that. I just want to confirm, did you take an appeal from the denial that you got of the zoning permit that you were seeking?
We appealed every possible way, every possible outlay of this. Being Native American, recognized by the state of Ohio and municipal court, we've built this with my father. This is a very important thing. He worked in building for his entire career, so it was great to have this on our property. It's so small, it's almost not noticeable. And the fact that we're here and the county has spent so much time and effort is just an arbitrary exercise of government power to take our property in a completely illegal way. We have filed for appeal in any way we could. On the record, Brian Snyder, after the ZBA hearing, we went July 14th, 2022 to discuss our ability to appeal. And he put, there's a number of options for your property following denial of your variance request. One which was the potential appeal of the case where the record of proceedings was discussed. I informed you that this information would be available to the public and something that was typically requested by your attorney as a part of an appeal to the Court of Common Pleas, and that we would provide that information as part of any appeal you may file. Our discussion mainly related to your intent to file an appeal. Even yet, he didn't give us our post-hearing documentation and instead gave us a citation. It's an abuse of power that needs investigated, and we need a permit or a variance for our property. I will close with due process and equal protection violations that we've adhered to or have been subjected to. We are Native American with the Pikwashani tribe. We were recognized by this on April 25th, 2023 by Judge Burchard when we presented our tribal enrollment card. Why this is important: the Northwest Ordinance of 1787 says the utmost good faith shall always be observed towards the Indians. Their lands and property shall never be taken from them without their consent, and in their property rights and liberty they shall never be invaded or disturbed unless in just and lawful wars authorized by Congress, none of which happened. So our request for relief is to reverse this decision, remand it down, investigate any of the due process issues, and please give us our permit. Thank you.
Thank you, Mr. Bragg. We appreciate your argument. We will take the matter under submission and issue a timely written decision. Have a good rest of your day. Thank you. That concludes our session this morning.
All rise. The Court of Appeals, First Appellate District of Ohio